So now let's talk about gifts versus loans. So obviously there are some advantages for each one. So let's walk through in detail, what are those advantages and why do you see certain clients or most clients, picking one or the other? What are some of the kind of most common fact pattern situations that you see?
Going to loans are a really good source if the party who's giving you the money is clean and if you are a high income earner, which means you will have no problem documenting repayment of that loan. Loans do not particularly work well for people that have no income, which we can talk about in cons, but it's very simple. Keep the terms of the loan simple. Make sure that you're abiding by the AFR interest rates. Make sure you're making monthly payments. Make sure that the sources are well accounted for, and make sure that the repayments are kept clean in case of an RFE. When you're borrowing from unrelated parties, it is much easier to sell the concept of a loan than it is to sell the concept of a gift from someone you've barely known or someone who's a friend, especially if that friend is not a high income earner.
Okay, and so in the situation where an investor is, considering making a loan, obviously you've, helped structure, hundreds of these types of transactions. Can you help the investors with, pointing them in the right direction of, the right loan agreement, the right note, those documents that they're going to need that have been approved in the past? Do you help your clients get all of that together if they decide they want to make a loan, but they don't have, a set of documents that they've used in the past to do something similar?
Yes, so we have our own internal template of a draft promissory note and an agreement for repayment that the USCIS has approved on several occasions. So that is the agreement we put into place between the investor and the lender. As long as the investor follows the amortization table and the interest rate published on that note, we have never had pushback from USCIS on approving these loans.
Okay, great. All right, so now let's talk about the negatives, the cons. So if you're doing a gift or a loan, what are the disadvantages for each that clients need to be aware of before they pick either one?
Collateralized loans are better than uncollateralized loans because USCIS knows that if there is an asset involved and the investor is unable to pay the loan, they can lose the asset. After Zang, we've seen a rise in unsecured debt, and we worry that USCIS is going to come back and say, you have nothing to lose if you default on this loan. Yes, your credit will take a hit, but you have nothing to lose, which is why we advise your clients to pay off the debt as soon as possible. Biggest downside is the interest cost. Specifically today, if you look at the AFR rates, you're looking at 5 to 6%. That is a huge interest expense for clients. It's better than going to a bank, which is a 9 to 10%, but it is still an interest expense. What is also important is that the lender needs to disclose that interest income as income on their tax return. If that is not done, that could be a cause of worry for the lender. And USCIS also wants to scrutinize loans to ensure that they're not disguised as gifts or that the repayment terms are not something that's not available on the market, which would indicate that it's not genuine.
Got it. Okay, so there definitely are some disadvantages to either gifts or loans. So it's definitely not a clear automatic decision for clients to go with one or the other. You really have to, examine the facts and circumstances. How much income is the applicant going to make over the next few years? How is that money going to be taxed? Have they gifted money in the past or not? In terms of the person giving the funds, is it a secured loan or not? So there really are a number of things to cover before you make a final decision if you should do, a gift or a loan. Now that we kind of have a better idea of advantages, disadvantages for each one, let's dig a little bit more into documentation. So for gifts and loans, what are those backup documents look like that are going to be filed with USCIS and that need to be kind of maintained in case any questions come up years later?
You will have to provide copies of loan agreements and promissory notes. The government is very interested in knowing what the terms and conditions of the loan agreement are. And again, as I previously mentioned, you want to keep a record of the repayment of those loans. Especially with consular processing, we have seen that the embassy tends to ask questions of the clients about what happens to the loan when they leave the country, that their home country, whether they'll continue to pay or not. And often we get requests for compliance reports on those loans. So it's very important that until that green card is printed, you have very good record keeping of loan repayments. And then if this is a not banking institution, if you're borrowing funds from a company that's not a banking institution, from relative, from a friend, then you need to source that party's source of funds just as if you were sourcing yours. You need to make sure that that person has legally earned the income and has paid taxes on it. You need someone who will cooperate to that end in order to show that. And to follow up on that, any interest payments you're making, you have to make sure that the person receiving those payments are paying taxes on it.
Got it. Okay, that makes a lot of sense. So let's talk about frequently raised concerns. So what are the things clients need to be concerned about if they're doing either a gift or a loan, and some of the most common questions that come up?
We've been asked questions whether clients can borrow using inherited land. Absolutely you can, but you have to go back to the principle of, if the land was inherited, how was the land purchased in the first place? Or how was the security purchased in the first place? What background do you have on the donor? Which can be hard to do if the donor is deceased. And if the donor is deceased and you had no relationship with the donor, it's 2 generations away. You have to write a sworn affidavit saying, I have second-hand knowledge that this person was legally employed or was in the farming business and has earned all their income legally. It sounds really silly, but that is the standard USCIS wants us to abide by, is to cover our basis and at least provide a sworn affidavit attesting that the funds were legally sourced. When it comes to loan, I think the biggest concern we have is the repayment of the loan. If we're able to get past the hurdle of how the lender acquired the asset or how the lender sourced the funds, the biggest issue we have is repayment of those loan funds. A lot of the times clients will say, hey, how about I sell my property in India and I repay that loan, say 6 months down the line. That is okay to do as long as you meet the 2 tests. The first test is you need to be able to source how that property in India was purchased. You need to pay tax on all capital gains that was generated through the sale of that property. If you're an H-1B holder living in the United States, you will be subject to tax in India as well as the United States, which means in India you will pay a capital gains tax. And because you're a US person residing in the United States, you'll pay a tax again. You need to make sure all that is clean before making that repayment. It's a very close relationship that we have to have with the client when a loan is involved, because we need to keep that repayment on a leash. Once that repayment is made, there's nothing we can do to fix the issue if there is any in the underlying source. So we recommend our clients that before they make any massive repayments on their loan, that they talk to us and we do the source of funds just as if we did the first time around. If there's any hesitation on both of these, gift or loan, on the opposing party to share documents, we do not use that source, because this is a 3 to 5 year relationship depending on the project you're going with. If the relationship sours or if the person stops cooperating, the entire application can be in jeopardy. There are a lot of questions raised around loans from India, whether you can borrow funds from India and then bring it to the United States. There are FEMA restrictions on remitting funds from India to the United States from banks. So if you're borrowing against a property in India and you're remitting that fund to, say, the United States, USCIS, if they find out that it's a violation of local country rules, can deny your petition. Same applies for Vietnam. If you do not use licensed money transmitters and you're using a broker that's not licensed to remit funds into the United States, that can be a basis of denial. So you need to make sure that you're complying with local country rules. For clients that come to us, I would say recently, because of the up and down in the stock market, a lot of clients have tax losses on their securities. And in order to cover the remaining funds, clients will come back and rely on loans or gifts. And those transactions take a little bit longer because not only are you working with the client, but you're working with the person that's lending the money, or you're relying on the bank that's lending the money, or you're relying on the relative that's gifting the money. So we tend to beef up and say, hey, we need 2 more weeks because we need to coordinate with your relative on the source of funds. I think that we get clients a lot of times that'll have 600,000, 700,000 that are waiting to patch the gaps. And the most common mistake I've seen clients make is they'll go to SoFi or they'll go to Upstart and they'll try and borrow money from there without realizing that those loans have restrictions on investments and securities. And depending on how your offering documents for the EB-5 investment are written, they're considered investment in security. So EB-5 is considered a security in some instances. And if you use that money to invest in an EB-5 project that considers it a security, then you violated the terms of the rule. So it's very important to read the loan agreement and make sure that the bank or the institution you're lending it from is actually a financial institution and does not have restriction. Another surge we've seen is through these LPs that are lending out money that don't have money transmitter licenses or banking licenses. USCIS is very clear with its regs that if it is a non-banking institution, you need to source where the money came from. So recently, the founder of SoFi started a new LP that lends out money for home equity line of credit. This is not a bank, it's an LP. And so we had a client who borrowed funds from that LP and we had to reverse that transaction, explaining to them that this is not a bank, and if the government comes back and asks us for the source, we will be unable to provide the source for the LP. So I think it's very important that before clients make the determination of gift or loan, that they talk to the attorney. Do not borrow funds. Do not start the process of investment without talking to attorney. Retain the attorney first. Brainstorm on the source of funds. We tend to take about 3 to 5 days brainstorming with our clients as to what source to use, whether a source is workable or not, whether they should be liquidating certain assets or not. We, as a boutique firm, only take a limited number of files per week, and we tend to churn those out in 2 to 3 weeks. And so we work very closely with the client. Client needs to be ready. There are clients that have been sitting with us for 4 to 5 months because they're constantly sourcing money from different sources. That is okay too, but it's much preferred that you speak to an attorney before bringing money into your account, signing a loan agreement, rather than just having all the funds in your account and then having to undo that transaction.
Great. Thank you very much. That was super helpful. And again, if you are interested in exploring an EB-5 investment and getting more information about the source of funds and what your application could look like, please reach out to Anahita. Her WhatsApp and email and website are there on the screen. And for any questions about the projects, about Twin Lakes, the rural EB-5 loan project, or our Boynton Beach multifamily project with a higher investment return, please reach out to us, WhatsApp or email, or visit our website, and we'll be happy to get you more information about any of those projects or other projects that we have open. So with that, thank you again for taking time to listen to the webinar, and we look forward to working with you in the future.